All right, can everyone hear me? Everyone had a good week?
Yeah.
Good. I've had a very busy week. I had the last 2 days I've been in trial in Jessamine County, and that's taken up all my time. I've actually not had very much time at all to prepare extensive lecture notes, and so my entire lecture notes is like half a page today. So I will be very extemporaneous. Did win the trial, so I'm stoked about that. But
What
but
was
I'm
the trial about?
my client was sideswiped on a motorcycle, and he was driving by the testimony of every single witness, including the defendant herself, driving exactly where he needed to be in the roadway, driving under the speed limit in the left wheel well, consistent with the Kentucky State Police manual of motorcycle operation. And it was just a matter of which party crossed the yellow line. All the testimony was my client did not cross the yellow line, and a jury in Jessamine County awarded my client $126,000.
Oh,
So,
good job.
yeah, so that was fun. A lot of work, but I really enjoy helping people out. And I really enjoy being here too. So, but like I said, it'll be kind of extemporaneous. Okay, so last time we started talking about the Commerce Clause, Article 1, Section 8, Clause 3 in the Constitution. And we read the case, the 1824 case of Gibbons versus Ogden, which is sadly our third and final opinion by the great Chief Justice John Marshall. And we discussed how that is the cornerstone, seminal foundational case, the first case in American history where the Supreme Court actually spoke to the meaning and the interpretation of the Commerce Clause. And you'll recall in that case there were two parties, one of whom argued for a very, very restrictive and narrow interpretation of this clause. A very narrow definition of the word commerce and a very narrow definition of Congress's power with respect to regulating it among states. So Ogden argued for a definition of commerce that did not include navigation or transportation, and Mr. Gibbons argued that the word commerce was very broad. And then it encapsulated all kinds of movements of people and goods, even for non-explicitly commercial reasons. And then with respect to the issue of how to interpret this clause among the several states, you'll recall Ogden argued that this phrase literally meant between one or more states, so it limited Congress's power to only basically taxes and duties on interstate trade and sales and transfers of goods and services. And then Mr. Gibbons, whose attorney was Daniel Webster, argued that for a much, much broader, expansive reading that basically said this phrase means in the midst of the states. Basically, Congress has the power to regulate all commerce in the United States. And Justice Marshall did not follow either one of those two extremes. Justice Marshall in the court read this to mean commerce that touches and concerns, that affects different states. The third question was an issue of federalism, and that was the notion of whether the states, whether and to what extent the states retained authority to even legislate on commercial matters. So Ogden had claimed that the states had not ceded any of their power to the federal government to legislate on commercial activity that was entirely within the state's borders. It was entirely within their boundaries. Only states had exclusive powers to regulate any of the commercial activity that was contained within their borders. Gibbons, on the other hand, argued that the states had forfeited all of their authority. So that's quite a bit of difference. And we saw again, Chief Justice Marshall split the proverbial baby and said, no, this matter of commercial regulation is a concurrent power. Congress has the authority to regulate commerce that concerns two or more states, that affects or concerns two or more states, as do the states. But if a state has a commercial regulation that is conflicting with a federal law, with a law that Congress passed, federal law is supreme, and federal law preempts the state law. And so, contrary to Gibbons' argument, Gibbons had argued that any state commercial law was ipso facto improper, was ipso facto unconstitutional. Marshall would not go that far. Perhaps Marshall would have wanted to go that far, but as we discussed last time, the political climate, especially particularly with respect to the issues of slavery and sectionalism, was such that it was so heated, so volatile of a political environment that a decision following exactly with Mr. Gibbons' arguments would have ignited a civil war 30 or 40 years earlier than it actually happened. So, any questions about Gibbons v. Ogden or about our initial discussion of the Commerce Clause? Any questions? We kind of left off last time talking about how this decision gave a very robust and expansive reading of the Commerce Clause, not quite as expansive as some of the high Federalists in the very 120 proof nationalists in the time would have wanted, but still quite a bit more expansive than most of the really ardent Jeffersonian Republicans, especially the Southern ones, would have wanted. But we talked about this had, because of the political implications of this decision and the one we talked about before, McCulloch versus Maryland, there was quite a political backlash. And so with the advent of what most historians call Jacksonian democracy, you saw a new kind of political zeitgeist that was very apprehensive, very circumspect of federal power. And so for a very long time, even though there was a decision on the books, this Gibbons versus Ogden decision that gave Congress, that interpreted the Commerce Clause in such a way that would give Congress very broad authority, Congress did not really pass any legislation pursuant to its commerce power. Very little until for a long time, until the very last decade and a half of the 19th century. And at this time so this was decided in 1824. And then 1828 is when Andrew Jackson gets elected. And during this time, there is a market revolution in the country. I'm reading a really good book right now that I recommend. I don't think I put it on the reading list. I'm about halfway through it. It's called What Hath God Wrought by Daniel Walker Howe. And it's a book, it's a very comprehensive, in-depth look of America between 1815, at the end of the War of 1812, and in 1844 at the eve of the Mexican-American War. Very good book, and it's about the transformation, the cultural, social, economic, industrial transformation of America, how dramatic and how expansive it was. And it's hard to overemphasize just how significant this market revolution, this market capitalism revolution was, and it had precipitated and kind of exacerbated the sectional conflict, the ideological conflict, the cultural conflict that precipitated the Civil War. And so there's a sense in which the Civil War was a culmination of one of the issues we've kind of discussed residually in this class so far, and that issue of federalism whether the relationship between the states and the federal government is such that it makes the federal government essentially a pact between the states, what is known as compact federalism, or if the United States is essentially one unitary republic. And so there's a sense in which the Civil War was a war about federalism, was a war of the compact theory of federalism as represented by the Confederacy, and the unitary theory of federalism, the more Hamiltonian notion of federalism as is represented by the Union in the Civil War. And there's also a sense, and of course this is not to detract from the fact that obviously slavery was the crucial underlying issue, the main catalyst, the main impetus of the war. But there's another sense in which the war was a struggle between modern commercial capitalism and what you might call pre-capitalism. And so what we talked about last time is this kind of political dynamic where you had a section of the country whose interests were tied up in Congress having expansive power to regulate interstate commerce, namely the North, the Yankee industrial, commercial, capitalist centers in the North, and the agrarian slave-based society of the South, supposedly, whose interests were threatened by the notion of Congress having expansive powers under this clause, expansive powers to regulate commerce. So that's the reason from Gibbons versus Ogden up until the very last few years of the 19th century, there are really no Commerce Clause cases from the Supreme Court to speak of, because Congress really wasn't acting pursuant to this power. It's not until the post-Civil War real, genuine advent of what is much more recognizable as a modern capitalist market economy, with the proliferation of the railroads and national businesses, where you have then the modern regulatory bureaucratic state rising to deal with it, to deal with this almost overnight growth of post-war capitalism. Yes?
Why do you think it was in the Constitution if it wasn't relevant until so much later?
Well, it was relevant. One thing we discussed last time was the thinking. We kind of looked at some of the theories behind the purposes of the Interstate Commerce Clause. One thing we mentioned is the Commerce Clause, one sense in which it's Congress's most important power is, many historians think this is the lack of this power under the Articles of Confederation was the very catalyst for the idea of forming a new government in 1787, because the Articles of Confederation allowed the states, the several states, to enact their own commercial regulatory regimes that inhibited and blocked interstate commerce. For instance, the Potomac River, where you had Maryland and Virginia share the river, merchants and commercial developers could not use the river to their gain because of trying to comply with laws from both states. And you had several instances of this, of where different states were, because they wanted to legislate in a way that would help their own interests to the chagrin of the interest of people out of state, that inhibited a national market. And we actually, last time we read an excerpt from George Washington's farewell address, where he expressed the notion of interstate commerce, or interstate intercourse, as he used it, as a kind of an adhesive bond that would maintain national unity and prevent sectionalism. Yes, sir.
I just was looking. Do you think that many of the other enumerated powers of the federal government could actually be subsumed in the commerce regulation, like borrow money, establish rules of nationalization, print money, regulate weights and measures?
Yeah.
Those are all
Well,
commerce-based.
It comes down to how narrowly or how broadly you understand this term commerce. What is within the purview of this term?
Even the post office in.
Is that commerce? Yeah, yeah. And that's the question. And as we go through these cases, you're going to see, how many of you had Mr. Van Hooser's class on the First Amendment last semester? Did anybody? Mr. Van Hooser, I had the privilege of speaking with him just before I walked in here, and we were talking about, I told him what we were going to talk about today, and he had talked about how just dramatically expansive the court's reading of this clause, as we're going to see, has been in the 20th century. Because another sense in which this is the most important power, arguably, of Congress is this is today the clause of reference, the textual basis of reference in the Constitution under which Congress passes probably most of its legislation was with reference to this power. Because name me something that's not commerce. Name something that's not commerce.
Where there, I'd have to be where there's no exchange of money.
Okay. Well,
And,
but even things where there's no exchange of money, as we're going to see, can things where there's no exchange of money still affect commerce?
What about churches?
Well, okay. Churches, this is where Congress would have might otherwise have power, but there's a negative restriction, namely the First Amendment, which would prohibit Congress from regulating churches.
No regulation, so that means
Yeah.
even commercial regulation cannot be applied to churches. Like if they have a fundraising thing
Mhm.
and the profits go to their central offices, which were out of the state of which the money was raised, then that would still not be considered commerce.
Well, it might be considered commerce. Let's say the First Amendment doesn't exist, then that might very well fall under this clause.
what about TV evangelism?
Well, it's religion. I mean, now we're going back to last year with my, and I remember you were in my religious liberty class last year. You can think of all kinds of religious examples that might be commerce, and that's one prong of it. Congress has these powers. For instance, Congress could pass a law banning the interstate sale of Bibles. That would be consistent with its commerce power, but it's going to run into the First Amendment. Do you see what I'm saying? It's going to run into it's restricting. It's putting a substantial burden on the free exercise of one's religion. Does that make sense? Okay. So post Gibbons, not a lot of commerce cases because the federal government is very restricted, not really doing much. In fact, we've only seen so far in the Marshall Court. Marshall, I believe, was the longest serving Chief Justice of the United States Supreme Court. On one occasion, did he ever strike down a federal law? In all the cases that he heard, did he ever strike down one section of the federal law? And that was in Marbury versus Madison, where he struck down Section 13 of the Judiciary Act. It would not, and that was in 1803. It would not be until 1858 until the next time that a federal law was declared unconstitutional. And that actually was Justice Roger Taney striking down some provisions of the Missouri Compromise Act in Dred Scott versus Sanford. That was the next time after Marbury in 1803 that a federal law had been stricken down. So that's all to say. Here we're going to flash forward. We're going to skip a whole bunch of time. We have been focusing on a lot of attention on the first 20 years after the turn of the 19th century. Now we're going to jump to the end of the 19th century. Now, we looked at the three questions that this case talked about. And what's ironic is that these three questions are the essential questions that really are at issue in every commerce case. Even though they're not really explicitly addressed by the court, these are really what's going on. And these three questions are: what is commerce? If we're looking at an act of Congress that's made with reference to this power, is it commerce that's being regulated? Is it commerce that's among the states that's being regulated? So what does among the states mean would be the second inquiry. And third, does the 10th Amendment limit Congress's power under this clause? The same way that we saw that the First Amendment would limit Congress's power. They may otherwise have power to do things, if not but for the First Amendment. Does the 10th Amendment? And what does the 10th Amendment say?
Powers not delegated to the United States, nor prohibited
Mm-hmm.
to the states,
Mm-hmm.
or reserved to the states respectively or to the people.
Reserved powers. So this is an issue of federalism again. If a power has been reserved to the states, and this is traditionally understood as a state sphere of activity, state law, does that limit Congress's power to act? States typically are the ones who are dog. Remember when we talked about the mail? We were talking about the necessary and proper clause. We talked about the hypothetical of Congress passing a dog catcher statute, basically, saying, "Hey, we have power to to establish post offices, and pursuant to this power, as a necessary and proper means to that end, we're going to pass a law regulating vicious dogs." Does the 10th Amendment, because that's a sphere of activity that's typically reserved for the states. States have always exercised that general police power of electing dog catchers and regulating animal control, things like that. Can Congress then, under the pretext of regulating commerce, do things that typically have always been left to the states and arguably are reserved to the states? So those are the three questions. Yes, ma'am.
If the states have greater authority than the feds in law enforcement, then how does the FBI come into states and catch a criminal?
Okay, so two things. One, I would say, I don't know if I would use the word greater. I would say different. Now, the states have general police powers, and the word police there is kind of not just is kind of a different kind of nuanced term, not just with respect to law enforcement, but all kinds of things. And then, so the states can do anything they want unless it's proscribed. The federal government cannot do anything unless it's prescribed, unless there's a power that's an enumerated power or an implied power that they're referencing. Okay? So it's not necessarily true to say that the states have greater power or that the federal government has greater power. There's just different orientations of their power with respect to the Constitution. The Constitution is a ceiling to one and a floor to another. Second, but I'll answer her question. I'll get right to yours. Second, the FBI is able to come into the states because they are investigating and dealing with issues of federal law. For instance, many of you have heard recently, I think maybe a month ago, there was a young girl who was found dead in Mammoth Cave National Park. There's like a finger of Mammoth Cave National Park that goes all the way down, I think it's Highway 70, and goes all the way to the edge of the interstate there. There was a young lady who was found dead in a cemetery there that was within the boundaries of the park, within view of the interstate, right there in Park City, basically. The FBI investigated that. Now, had this young lady been found 20 yards over or across the road, right beside the dollar store there in Park City, where it would be, even if it was government property or private property, no matter what, if it's outside of the federal park, then it's outside of federal jurisdiction. But the fact that it was a federal issue because it's in a federal park, or say issues, let's say someone is dealing with mail fraud, okay? You're getting the feds involved. Anytime that you're messing with federal law, you're getting the federal law enforcement, the FBI or the marshals, or whoever, whatever kind of federal law enforcement, that implicates them. So they can come into the states and in the normal operations of what's going on in the states to investigate and prosecute federal crimes. Does that answer your question? Go ahead.
Well, I'm just, after thinking about a terrible situation up in Clay County, Kentucky,
Mhm.
where the FBI was called in actually by a church group that had been gathering material
Mhm.
from the circuit court in Clay County
Mm-hmm.
against drug dealing.
Mm-hmm.
The FBI came in undercover and then started arresting people, and some of the people they arrested were officers of that court, the police chief, some policemen.
Mhm.
The circuit court judge was replaced, and the guy they replaced him with then was accused of drug dealing, and they had to replace him. So I didn't understand how the FBI was doing all that.
Because there's a federal drug trafficking statute.
Oh, okay.
So as we'll see, we're going to read that case, the Gonzalez versus Raich, dealing with Congress's authority, Congress's power to regulate drugs, illegal drugs. How does when it affects commerce? So that was if it's drug, that's an area of concurrent power. So there are state laws against illegal drugs, but then there's also the Controlled Substances Act and other drug trafficking acts that allow federal law enforcement. Yes.
What's going on right now between the sanctuary cities, which are claiming that they
Mhm.
have legal justification to declare themselves sanctuary cities, and a federal agency which claims it has the power and should be supported in its endeavor to do its job?
I would say that's a clash of federalism. The same way that in Arizona and Texas, there are some county sheriffs who are taking the same prerogatives to establish sanctuary counties or sanctuary cities for guns. And
Is that
so,
going to end up, is the only answer in a Supreme Court decision?
I won't say the only answer. I can say maybe what would happen if it went to the Supreme Court. The federal government, there's a case, Arizona versus United States, I believe. States cannot enforce immigration law. They cannot make their own immigration law insofar as that's what's known as field preemption. Whereas where Congress so highly regulates an area of activity that the states just ipso facto can't do anything.
Well, then how are they doing it?
Well, the same way that we're going to talk about things that Congress has done and maybe has done for a while, and then the court says, this doesn't comport with the Constitution. There are things that happen all the time that, for instance, there were people I went to law school with who went to public schools that still had school prayer. It's been unconstitutional since 1963. It still happens. It still happens. What are you going to do about it? Yes.
So I'm interested in this question of prescribed versus proscribed.
Okay.
So the federal level, things have to be prescribed, which means it has to be written down that it's their power.
The federal government is a government of limited powers, regardless of how big or small one thinks the federal government should be. At the end of the day, everyone has to agree that the federal government does not have general police powers.
So it should be specifically enumerated, but the question comes in all the definitions of stuff like the word commerce. Right?
Yeah, and that's
It's
where
not
we,
just a wide open.
and that's when we also talked about the implied powers of Congress that are kind of like a catch-all to things that relate to the enumerated powers. So you have the enumerated powers, and then you have the implied powers under the necessary and proper
And
clause.
you've got everything.
Well, that's in the discussion. Is Congress now practically vested with general police power. Even though in constitutional theory, all the smart aleck law professors can say, "Oh, Congress is limited." Is Congress now practically vested with general police power? Does Congress practically now have plenary
You can
power?
argue that anything is implied, then
Well-
there's effectively no limit, right?
Well,
Until somebody brings a suit.
that's the American way. Lawsuits.
They've got the
That's why.
power.
That's how I make a living, folks.
Could the federal government send in troops to these sanctuary cities and not let them be sanctuary cities anymore?
Could they or would they?
There's a law to say that the government can't use the military, which I would assume is troops. To enforce civil law
Didn't
unless.
Eisenhower use federal troops in
Yeah,
Little Rock?
He nationalized the National Guard.
Oh,
Nationalized.
Yeah.
yes, but they
And
would do
it
the
was
job.
the
Kent
directives
State, he
that
went
Yeah.
in and federalized them.
Mm-hmm.
It was
Yeah.
because of the Supreme Court.
Yeah. And now we're
Then.
we're drifting into questions of executive power, because outside of the Congress, outside of the power of Congress to make and declare war, the military is a prerogative of the executive, and I am not prepared to talk in depth about executive power. Maybe next spring we'll have a class on executive power.
Okay.
Yes.
I sent my friend a card,
Mhm.
and the mail normally goes from, I assume, from Glasgow to Nashville to be sorted.
Yeah.
Then sent, say, to Fort Knox.
Mhm.
And she got a card from a grandmother who greeted all her grandchildren. So I asked the post office in Glasgow, and they didn't know anything about it.
They didn't get the card that she sent, they got another card.
Somebody
Strange.
took everything out, and they say it was a guy, as of my friend, and said it was a guy in the
Strange.
car, but I never heard anything about it.
Huh.
So what?
Go to Washington.
That was
I don't
What
illegal.
was the post office?
Yeah, but he violated federal law.
Yeah, that would be the FBI could get involved. Now, there's also state law crimes, so it's not like if the district attorney decided not to prosecute you, you'd be in the clear. There are also analogous state law crimes for mail theft and mail fraud. But once you get in the mail, you've got that jurisdictional hook that gets the federal law enforcement, the federal prosecutors in the DA's office, and the federal courts involved. You're going to be going to court in the federal building as opposed to before Judge Wilson or Judge Grice in circuit court here.
So which law is he then breaking?
I don't know. That's federal criminal law. I don't know much about. I don't know much about federal criminal law, to be honest with you. Okay, let's keep going. Okay, so those three questions, what are basically our key questions for all these cases? What is commerce? What does among the states mean? And whether and to what extent the 10th Amendment limits Congress's power. Okay? Also, as we look at these cases, we will see that there have been two approaches to the Commerce Clause. And the courts have kind of jumped back and forth, kind of alternated between these two approaches. You have the first approach that could be called a categorical or a formal approach. Okay? The second could be described as a empirical approach to the Commerce Clause. Now, this formal categorical approach is very simple, very straight. Is it commerce? Is it not commerce? If it's commerce, Congress, you're good. If it's not, you're not good. Unconstitutional. It's binary. Is it local or is it national? Which is it? It's binary. straightforward, straight line. Remember we had a discussion last time about different kinds of judicial philosophies. Of some judges tend to like these really bright line, even rules that make everything very clean and trim and predictable legally. And then you have other judges who like several factor exhaustive tests, weigh balances and decide because they want all the decisions to conform with what's just. That's more of the empirical test. The empirical test, you could also call it the effects test. The effects approach, not really a test, but the effects approach. So some of the cases that we're going to look at, the court approaches the inquiry of whether something is a proper exercise of Congress's power under the Commerce Clause with, is this commerce or is it not commerce? This activity either is or is not commerce. If it's not, the law is unconstitutional because this clause gives power to Congress to regulate commerce. If it's not commerce, there's no power. Or it'll approach, is this a local activity or is it a national activity? Is it an interstate activity? Congress has power to regulate the latter, not the former. Categorical, formal, one way or another. The empirical or the effects test actually looks not at the formality of it, but looks at the actual phenomenology, what's actually going on. Does this activity in question that's being regulated, does it affect interstate commerce? If this thing were left unregulated, would it affect interstate commerce? Even if it is per se within itself not commerce proper, is it something that affects commerce? If it is a local intrastate activity that does not cross state lines, does it nonetheless, in its operation, in its phenomenology, does it affect interstate commerce? Can you see the difference in these two approaches? Yes, ma'am.
So, empirical or effect, that's really an extension of implied powers, right?
Not really. No.
Implied powers are an extension from empirical.
No. I would say that's somewhat of a conflation. Now, the implied powers are. We're going to see implied powers are implicated regardless of what approach the court uses in analyzing the power at issue. For instance, you take a statute that regulates, I don't know, the coal industry. Like let's say coal trains. Okay, you have a federal coal train regulation. Now, the implied power issue is going to be, is this coal train statute passed by Congress a necessary and proper means to the end of regulating interstate commerce? Well, that's going to come down to the issue of whether this actually is a regulation of interstate commerce. So the formal categorical approach would be, are coal trains commercial or are they not commercial? The effects approach would be, is the operation of these coal trains, is it something that in the broad scheme of things, in the realities on the ground, that affects interstate commerce? Can you see the difference there? So it's the issue with respect to implied powers is kind of implicated the same regardless of which approach a court takes. Does that make sense?
Would
Yes,
you
ma'am.
call, the argument that we hear today
Mhm.
is the living document,
Mhm.
the empirical effect approach versus the more conservative approach, which would tend to be
Well,
category of control?
I think again, those things can be mutually exclusive. You can have, and that's why the terms of the dichotomies of liberal and conservative are very difficult to apply in the jurisprudential context, because you can see where maybe people we might style as the more liberal or progressive people would tend to have this approach. And that's typically true. the more progressive judges and the more progressive Supreme Court decisions, as we'll see, have tended to take this approach. But that's not necessarily true. You can still take this approach and arrive at a conclusion and still have a conservative framework of analysis, I guess you'd say. That's on the ground, that's true. But it's not true by necessity, if that makes sense.
Of course.
Yeah.
Because you can go all around Robin Hood's Burn and still end up going in the door.
Yeah.
Just go in the door in the first place.
Exactly. Okay.
I have a question.
Yes, sir.
So I'm just wondering about effects. So for instance, farmers markets,
Uh-huh.
farmers are selling locally, but it's reducing the commerce across state lines. Kroger's not,
Hold that question till we get to Wickard versus Filburn. I'm going to call on you. If I don't, please just stand up and say, you promised you call on me. Okay? All right, so let's get through these cases. I'm excited to get to Wickard versus Filburn. Okay, so so you have all the way up until about 1887, Congress is really not doing anything, essentially pursuant to its commerce powers. Then in 1887, you have the Interstate Commerce Act. And it's dealing with the railroads, with regulating railroad rates. And however, also starting in 1887, you have the beginning of an era of Supreme Court history that is known as the Lochner era. Now, the Lochner, L-O-C-H-N-E-R, Lochner era. The name comes from a 1905 case called Lochner versus New York. The Lochner era of cases, the Lochner era of the court is from 1887 to 1937. In this era of the court was filled with judges primarily who had a very conservative, very right-wing orientation. However, whereas in our modern context, the conversation tends to associate judicial activism with the more liberal or progressive end or the left wing of the spectrum, these judges were what you would call, if anything, judicial activists. They made up rights that were not explicitly in the Constitution. The modus operandi of the court was guided by this notion of economic due process. This notion that the due process clauses in the 14th and 5th Amendments of the Constitution give people substantive economic freedom of contract that the government cannot hinder. For instance, Lochner, the very case of Lochner, had to deal with New York's minimum. The legislature of New York passed a law regulating the hours for bakery employees in New York. Set the standard number of hours, and basically it was an overtime law. And the Supreme Court said, no, that's unconstitutional because it violates the rights of the bakery owners and the employees to their freedom of contract. They have a substantive liberty, a substantive due process liberty of contract to arrange a contract of whatever those terms are. So if they want to make a contract that I will work for 30 cents an hour, 18 hours a day, 7 days a week, they are at liberty to make that contract, and the states cannot violate that liberty. Now, that's what I would call judicial activism. That is the court making up rights that are not in the Constitution. And so that's what the court in this period is striking down, state and federal laws, striking down all of these different attempts of the states and the federal government to enact economic regulations. So whereas before the Lochner era, you had case law and a court that was very open to federal power, to government power to regulate commerce, but you had a very inactive federal government. Now, the converse is true in the Lochner era from 1887 to 1937, where you have a very proactive federal government, a federal government that is becoming very proactive in commercial regulation, very proactive in bureaucratic administrations that touch and concern economic rules, but a Supreme Court that is vociferously hostile to such regulations, because those regulations impinge on what they see as economic due process liberties, namely the liberty of contract. Does that make sense?
Is that why FDR tried to change?
We're going to get there. We're going to get there. You guys are way ahead of me now.
So would that include the question of free association?
That's the free association is a First Amendment act. That is actually something in the First Amendment where you have the freedom of speech and the freedom to assemble. Something that's in the background there that's not even though the word association is not express, it's implied in the text that you have the freedom to associate with other individuals and the freedom not to be compelled to associate with other individuals in society. That's the First Amendment issue. I'd say that's a much easier reading of the First Amendment, even though it's not expressed, it is an implied reading, than reading the language of due process and saying that due process of law prevents. For instance, another issue was child labor. Okay, the courts struck down child labor laws because they impinged on the freedom of contract. The case that started this in 1887 was, I think, Mugler versus Kansas, and it was a case Kansas had outlawed alcohol production, the sales of alcohol, and there was a distillery, and he wanted to continue running the distillery, and the state of Kansas says, no, this is illegal here now. Alcohol is illegal. And so he went all the way to the Supreme Court, and the Supreme Court agreed with Mr. Mugler and said, yeah, you have a freedom of contract to make and sell your own liquor. The state cannot impinge upon your economic liberties. Yet at the same time, if you took issues out of the business commercial context and put it in the moral context, for instance, prostitution, the court is very quick to say that Congress has the power to regulate those activities. Because even though you have a more right-wing oriented, conservative-oriented court, they are judicially active. They're judicial activists in shaping and conforming the Constitution to comport with their political ideologies. It can happen on, I don't know, somebody tell me who said this. It's a quote I hear all the time. I can't remember who said it. Whether it's the right wing or the left wing, it's still the same bird. Who said that? I can't remember. Okay, so that's the Lochner era. And so I gave you a table of cases in the Lochner era of commerce cases. So you can imagine if the court has this ideological presupposition of economic due process, of the liberty of contract, where of this kind of almost radical notion of laissez-faire economics, then imagine how they're going to read and interpret the Commerce Clause. If commerce attempts to regulate the affairs of business, of individuals or corporations engaged in commerce, is such a court going to have an expansive reading of Congress's power to regulate or a narrow reading of Congress's power to regulate? Narrow. Even though it's separate, the issue of the Commerce Clause is separate from economic due process. It's not the 14th Amendment. It's still the same ideology that's reading this restriction. You see what I'm saying? So look at this table of cases that I provided. The first case you have is the E.C. Knight case in 1895. The Antitrust Act. Manufacturing is not commerce. Which of these two tests? Categorical. Manufacturing either is commerce or it's not commerce. What about this Addison Pipe case? It's another antitrust case. But here we see actually the empirical approach taken. Because the court here is saying That, what's that?
You're right. I mean, I'm looking at are you looking at the United States versus EC9?
No, now I'm looking at, so I talked about that one, now I'm looking at Addison Pipe. Addison Pipe and Steel Company versus United States. So look at, so in this case, the court said that private agreements can have the same economic impact and directly restrain commerce. Is this a categorical or an effects-based?
Thanks.
Or the empirical effects-based, okay? What about this Champion versus Ames? This is a lottery act. Now, it's 1903. Lotteries. This is shortly right before Prohibition. How do people back then view lotteries? Yeah, it's sin, okay? So the court strikes down, or I'm sorry, upholds the Federal Lottery Act, which prohibited lottery tickets across state lines because it said, hey, categorical approach. They're lottery tickets crossing state lines because it's a moral issue to people at this time. In this progressive era, as it was called, in the turn of the century era, you had this era of populism, and then after that of kind of bourgeois Protestant progressivism of moral reform, social reform, all these different reform movements, and had this been any other legitimate, respectable business, the court may have been predisposed to say, oh yeah, the economic due process, freedom to contract, you can't touch this. But when it comes to lottery, something that's at the time was morally dubious, the court tends to say, yeah, it's totally okay to regulate the.
But that seems to be empirical by your definition, and you said it was categorical.
Well, because the court is essentially saying the sale of lottery tickets across state lines is just categorically interstate commerce. It's really the effects approach was really not necessary here because you have articles of commerce crossing state lines. It's really not necessary to get into an effects. Now, if you look at Swift and Company versus United States, where you have another antitrust case, that is a very expansive effects-based approach, where you have the beef trust. And so this is where you have the notion of a stream of commerce. You don't actually have instances of goods or services crossing state lines, but you have an intrastate activity that is nonetheless connected inextricably to this stream or this flow of commerce that does cross state lines. You see all these subtle nuances in determining what is fair game and what's not fair game under this clause.
So how is the beef different from the lottery tickets?
You tell me.
I mean, you print them
We won't
somewhere and
condemn
you carry
you
them
for
across.
eating beef.
What?
We won't condemn you for eating beef.
Oh.
Well, I'll give you what I think is the real answer. If I were a lawyer, if I were speaking as one of the lawyers in this case, and I was not allowed to make this argument, I would say there was the zeitgeist of the time of progressive social and moral reform. For instance, think about Upton Sinclair's book, The Jungle, at this time. What did that come out in like 1910, 1912, somewhere right before World War I, I think.
But the carrying it across the state border would be the same. The border's the border. And the
But that's the issue here. Is the meat? This is actually dealing with not things that are. What's being regulated are certain points of activity in this stream of the beef trust. So, if you're familiar with how trusts work, you can either have horizontal integration or vertical integration. And so here it's an issue of vertical integration where you have one trust that owns the cattle ranches, that owns the butcher shops, that owns the processing plants, things like that. So here, when you have one section of that vertical trust, that vertical chain, you have the slaughterhouses. Even though the slaughterhouses are intrastate activity, they are tied up in an inextricable chain of the flow of commerce that does touch and concern and affect other states because it's a trust. Do you see how that? Now, if you want the honest answer, it's the progressive social reform zeitgeist of the time was very interested in making safe meat for people, and not so interested in prohibiting what they saw legitimate exercise of contract rights. You see what I'm saying? There's going to be inconsistencies, and there's inconsistencies in every area of the law. Every area of the law, and the job lawyers have is to make things seem consistent when they're really not. Okay, let's keep moving through these so we can get to Wickard versus Filburn hopefully by the end of the class. Then you have the Hippolyte case. I would say, I just want to kind of breeze through these. In the Hippolyte case, you have a categorical approach with the Pure Food and Drug Acts. In the Hope case, that's actually the Mann Act, which is the Prostitution Act, and this is a categorical approach. And then Hammer v. Degenhardt, turn to the back page, 1918. This is an important case. Now, this is the Child Labor Act. Congress said, this is not a regulation of commerce.
And they got around the contract situation, didn't they?
Yeah, they didn't have to touch and concern economic due process and contract rights. This isn't, Congress, we see what you're trying to do. You're not trying to regulate commerce, you're trying to regulate labor conditions. And labor conditions are a sphere of activities that's reserved for the states. The employment relationship is a state law issue. That's a 10th Amendment issue. Okay, the next one is the Houston Railroad. This is also called the Shreveport rate case. This is an effects-based approach. I'm just going to zoom right through these. You guys can read these on your own. I just want to show you how there's kind of this oscillating, this flipping back and forth of these different approaches, because the court tends to use whichever approach fits the end that it wants to achieve here. In Stafford, you have another, the Packards and Stockyards Act. I would say that's a categorical approach. It's another one of those stream or current of commerce things. And then now you're into 1935. Now, someone who brought up FDR in the court packing? You did. Okay. Why did the court packing thing happen? Why was there an interest on the part of FDR to pack the court with judges?
The Supreme Court wasn't agreeing with some of the programs that he instituted, proposed, whatever.
Yeah. So in the New Deal, you had this litany of alphabet soup programs, the AAA, the Agricultural Adjustment Administration, you had the Works Progress Administration, the Civilian Conservation Corps, National Industrial Recovery Administration, all of these different, plethora of these three or four letter terms. There are all these different government programs to recover the economy, but you still had this remnant on the Supreme Court who was still operating from this ideological orientation of the Lochner era, of this economic due process, government hands-off, laissez-faire. Government cannot be involved in economic regulation in most cases because it affects the economic due process liberties of contract. So you see that in the last two cases here. You see it in the Schechter case and in the Carter-Cole case. In both of these, you see a very categorical or formal approach here. So with this Schechter case is also called the sick chicken case. And so essentially the argument here is it's a slippery slope argument really that the court makes is if Congress can regulate sick chickens, then what can they not do?
Why would anybody be shipping chicken?
For the same reason that people would be shipping watered down milk and baby powder in powdered milk and things like that. I mean, have you ever read Upton Sinclair's The Jungle? Well, what's being shipped out and everything? Because you're wanting to cut overhead and turn a profit. Then in the Carter-Cole case, here you have a very straightforward categorical approach, production is distinct from commerce. Production, the production of goods is not commerce. So in this case, the Coal Act tried to set minimum wages and prices and minimum hours or maximum hours for the coal industry, and said that any coal that's produced not pursuant to these employment regulations and price regulations cannot be sold on the interstate market. And so just like in Hammer versus Degenhardt, you had the court saying, are you really trying to regulate commerce, or are you trying to regulate something that's not commerce? And so they said the production aspect of it is not commerce. Categorically, it's not commerce, therefore Congress hands off. Now, eventually things changed. And the FDR administration did not, even though it threatened, it really didn't have to engage in its court packing endeavor, because the different justices came onto the court, and there was actually a judge or two who kind of had an ideological transformation and started seeing things a different way. And so then if you look at this case, the Jones case, National Labor Relations versus Jones, what do you notice differently about this case? This case in 1937 marks a new era in the Supreme Court. The Supreme Court has gone from a court that is out to obstruct all of the federal economic regulatory agenda, to a court that is out to vindicate the federal regulatory agenda with respect to economics and because you have a different ideological zeitgeist that's getting onto the court, whereas before you had the kind of economic conservatives, the laissez-faire oriented ideologues. Now you have people that are coming from a Keynesian economic perspective that are getting onto the court, that see the federal government as something that is not an enemy to contract rights and commerce, but as the notion of government regulation being essential and indispensable for maintaining a capitalist economy. Well pumping, as they called it in the school of Keynesian economics. And so you have an ideological change on the court. And so you see that exercised in the first time in this Jones case. And so that's why this case marks the end of the Lochner era, because the court starts going a totally different way. And so in Jones, you have an effects test, a very pure effects test. So what's going on in Jones? What do the NLRA do? National Labor Relations Act, also known as the Wagner Act. It legitimized unions. Yeah, it set up a statutory framework that governed how unions and management bargained collectively. And it protected collective bargaining rights. And it set up a playing field on which companies and unions could negotiate and could bargain over labor conditions. And so you had a company that was just going to keep on holding out and not complying with the Wagner Act and refusing to bargain with organized workers. And their argument was, this is not constitutional. Labor relations is not commerce. That's in step with many of the decisions that the court had decided before, right?
Well, that's what I was going to ask you, because you said one of the big factors in Supreme Court decisions is precedent. Now, all the precedents, the few that we've taken a look at, would have indicated that this act was unconstitutional.
It would, wouldn't it?
So what? They just threw out the precedent?
Not in this case, but in the next case they do. Not in Jones, they don't. In Jones, they don't. They do not. There is no cases that are really explicitly overruled in Jones. Jones is the rule from Jones that activities. So the rule that you need to remember from Jones is that activities can still be wholly intrastate. Yet when you separately consider them, namely labor relations, they have such a profound effect on the national market that Congress has the power to regulate intrastate activities, certain intrastate activities. So it's a very robust effects approach. Now, the next case, because think about this, it's 1937. What's about to go down in 4 years? World War II. Does it touch and concern, is interstate commerce then becomes an indispensable facet of national defense. If you have steel workers that are on strike, and you have owners of steel mills that are not wanting to comply with the law that was passed to keep things going, to keep the economy going, to keep producing things for national defense and recovering the economy from this stock market collapse, then that's going to, all of these individual instances of intrastate labor relations has a profound effect on interstate commerce. It affects everybody. If Henry Ford in Michigan refuses to bargain with his workers at the Dearborn plant, it doesn't just affect people in Michigan. Even though it's an intrastate activity, it has an interstate impact. That's the logic here. Now in Darby, we do see an express rejection of precedent. We see the court deliberately overruling Hammer versus Degenhardt. Whereas in Hammer versus Degenhardt, there was a very categorical rule: labor conditions, employment terms are not commerce. Categorically, formally not commerce. The court totally reversed itself and deliberately overruled Hammer and said that even things like manufacturing and labor conditions, even though they are not commerce, they are categorically not commerce, they don't have to be, because the interstate shipment of goods that are manufactured under unfair labor conditions affects commerce. It affects commerce. You see? So do you see now this dramatic change? Court has done a 180 here. Now let's take a very short break, and I'm going to speak with this gentleman when we get back about Wickard versus Filburn. How about that?
What was your question?
It was something about with farmers markets. Okay.
Farmers markets.
Yeah, he's going to refer to the case.
And they were unanimous.
No, not really.
Seems like some of them were.
It's hard for me to see how anything stays in the state. I mean, you put the goods on the truck, even if you're just driving from Boulder Range to Louisville, and if the gas came from somewhere else, the guys probably from somewhere else. The road is made stuff that comes somewhere else. Nothing is interstate 100% anymore, but everywhere is.
And if nothing is interstate, does that mean, is there anything? That's the question this is ultimately building up to. What is off limits? What can Congress not regulate? That's what we're going to build up to. I'm giving away the ending of the
They
show.
regulate anything they want to please you.
Well,
And the big change was that they were unanimous in their decision.
Yeah,
No dissenters.
yeah, that's right.
But, times change, the communications change, railroads change, roads,
Yeah, it's a different
new
world.
world is coming. And
Different
things
world.
have to be quite different. So, as far as, what do they call the cities that want to not identify and send away their illegal aliens? Number one, they can't make you report a crime, or actually, it's not a state crime to be an illegal alien, probably. So the state officers aren't required to enforce it. And the things that the government asks to do is to report it. They don't necessarily have to. Number two, they ask people to keep their people in confinement for longer when in fact they didn't have a reason to do that for state law.
Mhm.
And so I would think all they have to do is just do those things and don't say you're a sanctuary city and you'd be allowed to say.
Yeah, you'd be a de facto sanctuary city, yeah. But I mean, the issue is, what's coming to a head, I think, is the fact that cities take federal money. And there's the old adage, he who takes the king's coin is the king's man.
No, but federal money is our money.
Yeah, that's the issue. It's not, the money that San Francisco is taking is money that comes from, that it got into the federal coffers from people from Brownsville, Texas.
Uh-huh.
See what I'm saying? Or it came from people from Arkansas and Mississippi, people who are not so crazy about sanctuary cities. So when you have cities that are enacting a sanctuary policy that are accepting federal grant money, and that's what we're going to get into when we talk about the taxing and spending clause. To what extent can Congress condition federal funds on certain things? So if you have the cities that are accepting federal money, does Congress then have the power to rescind federal funds to cities that are doing that? The same way that they might with the cities that have the gun sanctuaries.
Or,
They're probably
yeah,
not fascinating.
guns has got to be different. But it's like the education,
Yeah.
that if you have a college and you take federal money, then
You have to have Title IX compliance.
You have to have Title IX compliance.
Yeah.
And let's see.
We're going to get into
I
that.
think That's
We're going to, when we talk
it's
about
been a
taxing and
big
spending.
thing. And yeah, okay, we'll get that. This is pretty interesting.
A little bit, yeah. I thought so myself. That's why I was eager to teach it, eager to have a class on
But
it.
the world changes so much. Oh, so and actually even the president can't tell people not to obey the law, can he? Or
The
is that-
president can't tell people not to obey the law.
to not obey the law like he did. He told the people on the border, says, listen, don't let those people in. You don't have to do that. Really, he did.
So told, okay, I'm not sure.
The president was in a meeting with some of the enforcement people
Mhm.
on the border the other day,
Mhm.
and he said to them, kind of aside, listen, you really don't have to let those people in. You really don't have to set them up with their meetings and stuff. Just
Mhm.
keep them out, and you'll be all right. I'm on
Oh,
your
I
side.
see, okay, with the procedural requirements for
Yeah.
bringing in asylum seekers and things.
Yeah.
Okay, yeah.
So,
Yeah.
I said, people, wow,
Yeah.
can the president really do that? Is that kind
Well,
of, is that
maybe
a bad thing?
that's a question for maybe next spring when I might teach a class on executive power. We'll see.
And so then they said, well, the officers of those particular people came in and told them, no matter what he says, you have to follow the law.
Yep.
But that would be an illegal order. And even in the military, you're not supposed to follow illegal
Yeah.
orders.
Yeah.
And that would put a lot of people at risk.
Absolutely.
They're in the military too.
All right, we all back? Maybe give another minute or so, or?
Very complicated situation, but when he's around,
We can look at it the day after.
they'll have to.
Okay, so we are in the thick of the New Deal, 1942. Not only in the thick of the New Deal, but we're in the thick of the Second World War. And so we've seen in the last two cases a 180 flip from a Supreme Court that has been hostile and obstructive to congressional efforts to regulate the economy. And now we have a Supreme Court that seems to be going the other direction. Seems to be reading the Commerce Clause in a way that's progressively expansive. Now, when we get to Wickard, Wickard is a very controversial decision. Can you imagine why? Wickard versus Filburn, 1942. Yeah. What's going on in Wickard versus Filburn? Somebody tell me.
Beg your pardon?
What's going on in this case? What are the facts?
A guy is growing wheat, I guess it is.
Wheat.
What's he growing?
Wheat.
Growing too much wheat.
For his own
And he
use.
has a quota,
Yep.
which has been established by the federal government that he
Mhm.
can only grow this much.
Yeah.
But not being an idiot and having a spare field, he grows a little extra just for his own use.
Well, I mean, of course, now understand the government's rationale in enacting these quotas. One of the main catalysts of the Depression had been really the same thing that you had seen when we talked about the Panic of 1819. With this, you had a post-European war. You had this very devastating war in Europe that left European civilization pretty mired and wounded, and dependent upon outside food source, outside food agricultural production. So in the early 20s, you had American agriculture booming, and so there was a agricultural bubble. You had people cultivating every bit of arable land they could find, planting everything and corns and wheat, and because there was a hot market in Europe after World War I. Well, it causes two problems. One, Europe, just like happened after the Napoleonic Wars a century earlier, gets back on its feet, and the market, the demand, the bottom falls out of the demand. So you have all these farmers that are tied up their credit in buying all this land and cultivating all this land that now have no market for this oversupply of crops that they've grown over the last 5 years. Second, if you've cultivated everything, causes the Dust Bowl. So here you have and of course the Dust Bowl doesn't, I mean if the price of crops going to nothing is not a hard enough thing on farmers at this time, the Dust Bowl sure is enough to make up for it. So you have the federal government trying to regulate, not only regulate agricultural production in a way that preserves the integrity of the soil, but mainly is a market regulation to prevent the same kind of thing from happening where you have this overproduction that is going to make virtually it's not going to be profitable at all to farm. Yes, sir.
But with the war going on and all the stuff that was being rationed at the time, why would they have needed to have kept production of wheat down? Because people were doing all that stuff.
Because it was still, even in the midst of that, it was still an issue. It was still the government still wanted to be, because it was preemptive at that point. If you have Europe at war, I mean.
But the federal government wouldn't go into a shoe factory and say you can only make 42 pairs of shoes every other week.
Well, would
Why
they?
can they go into a farm and say you can only grow 10 acres?
Because one, let's say all of the shoe, let's say 80% of the shoe industry goes belly up. I think we could cope with either learning to make shoes out of duct tape or going barefoot. Let's say that 80% of American farmers go belly up. That's going to be harder to deal with. Second, the shoe industry had not been a substantial factor. One of the probably three substantial factors causing the market collapse in 1929. Agriculture had. So it was a matter of here's the snake that was biting us. This is the head we're stepping on. It's not shoe companies. It's now if we're applying it, if we're looking at it formally, if we're calling it's apples and oranges in one sense. But if we're looking at it even-handedly, if we're pretending like we're Lady Justice with a blindfold, I get your question. Your question then becomes a very astute one. If Congress can do this, can they then do this? And that's the whole inquiry here. If Congress can do X, can they do Y? Yeah, and that's what we're going to get into. Congress.
They're headed for Y on a
Yeah.
They argue
straight shot.
Yeah. So okay, so you have Roscoe Filburn, okay, and how much wheat is he selling? None. He's like, I'm just little old Roscoe Filburn. I'm not selling none of my wheat. I'm just feeding it my own cows. This is a pitchfork I'm holding here. I'm like in a Grant Wood thing. I have an invisible pitchfork.
And he's not selling his cows?
Ooh. Or, well, let's, I don't know the answer to that. Maybe he is.
I have a question.
Yes,
I
yes,
actually
yes.
don't know. Was the government at that time subsidizing the price of that wheat?
I don't know that.
As part of the quota system?
There was that one of the things that the AAA did is there were subsidies involved with agriculture. The same way that and this has continued. The Farm Bill every year has always done this, especially with the dairy industry. I mean, I don't see how the dairy industry could actually work without federal subsidies. But it was the same way with wheat at this time. So that was part of it, but that's actually not what's a constitutional issue. It was what was constitutionally being challenged is, hey, you know what? I'm Roscoe Filburn. I'm just little old Roscoe Filburn. I'm just growing wheat for my own consumption and for my cows. I'm not. This isn't even leaving. Not only is my wheat not leaving the state, it's not leaving my farm.
Right.
So Congress, if you're a government of limited powers, you're telling me that you can stick your arm not only into purely intrastate, but you can go and touch and regulate things that aren't even leaving my own property.
Not in my opinion.
So that would be the argument. But if I'm Roscoe Filburn, one of you tell me why I'm wrong.
Because their argument is.
Now you're siding with me. You're already on my side. I'm looking for somebody else who can tell me, who can argue with both of us.
He's Filburn, tell him why
Yeah.
he's wrong.
Why am I wrong?
Because if everybody kept their wheat, then there wouldn't be any for all hungry people somewhere else.
All right.
So
What does the court say here? What's the court's reasoning in upholding this?
Because if every other farmer did this, it would have a cumulative effect
Yeah.
on interstate commerce.
If everybody emulated poor little old Roscoe Filburn,
They
it
don't
would.
buy wheat.
Yeah, nobody. There would be no wheat market.
Only the people who grew it
Yeah.
would have.
Has anybody ever studied philosophy or ethics? I'm trying to remember the name for this. In Immanuel Kant, Kantian ethics, he had these 3 universal ethical rules. One of which was what is it?
Categorical imperative.
Yeah, categorical imperatives, where it's presume if everyone is doing this. I mean, I think that the court is waxing Kantian here. if everyone does this,
That's
then
a big if.
yeah, is it? But yeah.
Upon which to establish law.
Well, but then we're going to read these next 2 cases that deal with racism, that we're making really kind of the same if. What if everyone did this? So I'm back to being here's my invisible pitchfork. I'm back to being little old Roscoe Filburn. So you're telling me it's okay that the government. Now I know how you feel. But somebody tell me why it's okay for the government to tell poor little old Roscoe Filburn what to do with my own wheat. Hey, this wheat's staying on my. I'm nobody. I'm just little old Roscoe Filburn. Tell me why I should get on board.
Well, he is selling a portion, or he is selling the legal portion of his crop. So he's
No, I'm not.
anticipating.
He's not selling it. He's not selling any wheat.
I thought he grew so much and then he grew some extra.
Yeah,
So
he did.
was using
He
hay.
grew in excess of his quota.
I guess I made the assumption that
Yeah.
he was marketing
No,
the wheat
that's the issue.
that was legal.
Is this commerce? What is being bought and sold?
The quota.
The quote. What do you mean?
He sold his quota.
No, he's not selling anything.
He kept everything.
He's not buying
The
it.
regulated prices of agriculture.
So let's go back to the farmers market.
Yeah.
Okay. Can Congress regulate farmers? Can Congress?
He's not helping anybody else by buying their product.
I mean, surely, if Congress can regulate what poor little old Roscoe Filburn, whose crops are not even leaving his own property, then what about farmers markets?
Yeah. If he hadn't done that, he would have had to buy wheat, and that would have made
Yes.
the price. What he's doing is not going to,
Yeah.
is going to affect the price everybody did it, and it would create more chaos. So this is for the greater good.
Do you see, and you're gonna see, you see this now, you see the market theory of the kind of economic theory behind constitutional law that you see exemplified here and in other opinions. It's what Congress is trying to regulate a market. And if people can get around this regulation, then it's going to make supply and demand fluctuate outside of what Congress wants it to do.
Like Adam Smith wouldn't like them.
But John Maynard Keynes would. This is not the heyday of Adam Smith's time anymore.
But what if then they can come to this farm and say, oh, we have to confiscate or what?
Now, okay, here's something. It's not like the G-men showed up at Roscoe Filburn's house and like slit all the throats of his cows and burned his barns down. They fined him $50. Or like what's the equivalent of $50 today? Like that, you see, like it was a small fine. This guy was a plant. I mean, this guy was he did this to try to have a case. He did this as a point. Do you feel sorry for him now?
No.
He did it, how do you know he did it?
Well, okay, the same reason that there's all these people, and I'm not questioning Mr. Filburn's. He was a real farmer, and I'm not questioning his integrity or his honesty as a person. But there are people who will do things just for test cases, just to try. And so what's going on here is you have interests that are wanting to have a test case, to go to the court, to show, hey, this is how ridiculous this is. And so Mr. Filburn was this test case. It was, okay, I'm going to push the limits, and so that I can be fined this nominal amount of money, and then take it to the Supreme Court, litigate it.
Okay, just a little bit out of the country.
Okay.
Last year was a drought in Europe,
Mhm.
and wheat went down.
Mhm.
Russia too, they say. So people try to get the hay after and get the hay in because you need that for in the winter.
Mhm.
And there are some people who did not have enough. So a guy went to another guy and said, "Do you want to sell me your hay because you have enough?" And he said, "No, I don't sell any because I need it out for myself." I
Mhm.
think that farmer has to sell his cows, reduce his production, and you know, I don't know who's. Then I was asking myself, who's helping them? And it's the farmer at the end who cannot do anything. Like
Yeah, and at this point, you have a national market economy. I mean, no one, well, anybody contest the fact the states, now you can contest the fact that whether the state should or should not, but the state of Ohio definitely could have told Mr. Filburn how much wheat he could grow or not, right? Because the states have general police powers.
No.
Well, as a policy argument, maybe not, but as constitutionally speaking, it's unquestionable. The states can regulate these kind of things because they have general police power. Now, you're saying maybe not from maybe they shouldn't, but as far as the Constitution goes, that the states could. The issue is, can the federal government do it? Because this is how much more local do you get than somebody's own farm?
So that was
Now, who brought the
1938.
test case issue up? Did the farmer take it to the court, or did the court use his particular thing just to make their?
No, he did. He did, and it really wasn't him. It was lawyers who wanted to have a case like this. Who, you see what I'm saying? So on one point, he's a real farmer and he's really growing stuff. But it was a matter of the substance of it was, hey, you're a farmer. We want a test case. We're lawyers that want to stick it to. We're the ACLU. More or less. It wasn't the ACLU that did it, but it's something like the ACLU, that is just an advocacy organization that wants a test case.
So in case of like.
But does that matter? Does it matter if he's a test case or not? He's a farmer. What if he wants? Does it matter or not?
No,
that
it
he's a
doesn't
test case?
matter.
Still the issue. Still the same issue.
A couple problems. One, the law was in 38 before the war, so it took actually quite a bit of time, 4 years, to get up to the Supreme Court for the matter to be settled.
Well, I don't know that he actually just violated it in 1938, because these quotas went on in until after the war too.
And the purpose of the quotas, of course, the Agricultural Adjustment Act was an effort to save farmers.
Yeah.
And so the purpose of the act was actually not to keep it from growing that grain. It had a much bigger purpose.
Mhm.
And so I think the way I would see it is, some people say, gee, it doesn't make any difference what the purpose is.
Yeah.
We're going to get it because the government can't do that.
Yeah.
And the court said, well, yeah, they can, but we don't know if it's for a good purpose or not.
Yeah,
Doesn't make
I
any
mean,
difference.
at the end of the day, I mean, I'm gonna step into, here I stood with my pitchfork, I'm a little Roscoe Philbin, but now I'm a bureaucrat. And I'm one of the regulators with the AAA. Mr. Philbin, we want you to continue having a farm. We don't want you to be one of the tens of thousands, perhaps hundred thousands of Americans who have lost their farms and who are no longer gonna be able to farm ever, and are now migrant workers who have gone to California. They're characters in John Steinbeck novels now. We don't want this to happen. And so this kind of regulation is necessary to preserve American agriculture in this international and national market. So I'm sorry that you feel that your liberties have been violated. But we think as Congress, we have the constitutional imperative to regulate commerce in a way that touches and concerns, because as some of you point out, if he's not buying wheat off of his farm, that's just one effect, small effect. But if everybody did that, we'd have a big problem on our hands.
But what makes you think you can operate a market that efficient?
Yeah.
I mean.
All right, let me pick my pitchfork back up.
Who appointed you?
Yeah.
King of all,
Well-
that now knows exactly what amount of wheat everybody should grow in order to maintain a market that will
Well,
not collapse.
okay, if Congress enacted this act, then the American people would. Our people would. Really? I mean, wouldn't that be true?
I'm sorry.
If the American people, through their representatives, have enacted the AAA, so the people in aggregate have decided this is what's best.
They did it in 1938.
Okay.
I mean, they did it.
Takes a little time. The other thing is,
Gee, you mean you'd rather cause the depression? Would you rather do it that way? And help people to
Just
suffer?
explain to me how you think you understand the market in such a way that you can define exactly what my quota should be in order to maintain this
you know
perfect
what?
market.
We're gonna try it and see, because it's better than having people out of work, not eating. And, I've heard people from the Depression, and they all said, there was plenty of food. We just couldn't buy it. We couldn't get it because we didn't have money to gas. But farmers had stuff that was rotten.
Well, two concerns on both sides. You can have all the liberties you want and starve to death, right? That's the issue. That's what the government regulation is intended to prevent. You can have all the civil liberty you want, live in a libertarian utopia where the government doesn't do anything but deliver the mail, and you can starve to death because of a runaway market crash. On the other hand, pitchfork back up here. The exigencies of the market do not diminish or increase my rights. My rights are what they are, regardless of what the economy's doing.
That's categorical.
Well, is it that? That's kind of this is getting very profound.
That is natural
Well-
law versus.
You can have all the natural law you want to and starve to death.
Well, you have all the
It's
control
a-
you want.
Give me what you're giving
How
me.
many
Or you
million-
can be the kulaks in the Soviet Union and have all your grain taken away from you, and you can starve to death.
And this is let's talk about these next two cases. And we have the Civil Rights Act at issue here. let's see, we have like 5 more minutes. We'll start to talk about these. Do we have? Oh, I'm so sorry, we're over. I was thinking 7:15. We're way over. We'll talk about these cases next time. But we have Congress with the Civil Rights Act trying to regulate something that is undeniably terrible. Racism. Undeniably terrible. But is this regulating activity? The argument is a government that has the power to regulate all the things that we think are bad can also do something that regulate things that we don't want regulated. And so it's tough to talk about these cases, racism and violence against women and bringing guns to school and things, because they're the things where we're like, there ought to be a law. Somebody ought to do something. But that somebody who can do something can also do other things. And that's the discussion here. That's the very lively discussion we've had that I've enjoyed myself. I don't know about you guys. I love this. All right, I'm here to take questions. If you have any questions, please come up and see me.